Any mention?
Yes, Mr. Shan.
Please, Lordship. Lords, I beg to mention item number 9 of the hearing list. I've taken the consent of my learned senior. It has kindly come up after 4 weeks. This matter is pending consideration before the union government with regard to the merger of the cantonment civil areas with the state government.
Okay.
8 and 9 same, it will be same.
They're connected matters.
Correct.
On the
Item number
request
8 and
of
9.
both the parties, list is met after 4 weeks. 4 weeks.
4 weeks. Highly obliged.
Only 8 and 9.
8 and 9 minutes.
8.
9 I am appearing, 8 Mr. P. Nongri is appearing. He's already informed me about it.
Yes. 8 and 9.
Says there.
7 and
8 and 9.
You're for 8. Ratan.
8. Yes, your Lordship. 5 and 8. 4 weeks is coming out. Yes.
Item number 1.
May I please, Your Lordship?
Yes.
Lordship, this is the matter which I had to withdraw with liberty to file afresh due to some technical errors in the petition.
We'll issue notice then.
My lord.
Okay. Miss P. Agarwal, learned counsel for the petitioner. Issue notice. Returnable in 3 weeks. Yes.
I'm appearing for the private respondent. I filed the record number. No, this may be served on.
How many respondents are there?
2 respondents are there, my lord. The respondent number 1 is the state government, and respondent number 2 is the who was the complainant before the learned Lokayukta.
Yes. Okay. We say issue notice returnable in 3 weeks. Mr. N.D. Shulai, learned AG, APS for the respondent number 1. Mr. P.T. Sangma, learned counsel, enters appear on behalf of the respondent number 2.
Lordship, 2.
Then you'll be needing a copy of these things.
Lordship.
Yes, my lord. We'll be supplying it. It's already there in Shillong. My colleague will provide it to him.
So just you provide him a copy of the thing. Okay.
Yes, my lord. Yes, my lord.
All the respondents are represented. No formal notice is called for. The list is met after 3 weeks.
Deeply obliged, my lord.
Item number 2.
May it please, Your Lordship.
Yes, Mr. Paul.
Well, this is a application under section 482, my lord, challenging the order dated 21/9/2023, freezing the bank accounts of the petitioner, my lords. Now, I have no relation to what case is going on, my lords. I am not an accused there. I am not informed, my lords, on one fine day when I'm trying to, my lords, service a loan and the servicing of the loan fails, my lords, when I make inquiries with the bank, I am informed that there is a freezing order, debit freeze order issued by the respondent number 1, my lords. There are certain parameters, as your lordships are aware, my lords, which have to be followed before any debit freeze order can be passed. None of that has been followed, my lords. And in the meantime, some ex parte or uncommunicated order has been passed by which the debit freeze has been made. Your lordships would find that at page 26, my lords.
You are not an accused in any criminal case.
I am not, my lords. I am not being investigated into any case. Had I been, my lords, I would have had some notice or something to show, my lords, that
It must be something like the proceeds of some illegal.
or connected with some illegal act somewhere, my lords, if 120B is to be attracted.
Deposited in your account.
Lordships.
Now, if something comes to your account, you must be at least aware of that. You may not know about the pendency of criminal inquiry against you.
Any credit into my account, my lords, I'll obviously know. But even if there is credit, my lords, the state in the first stage of investigation would issue notice to me, my lords, to ask for some explanation as to how this money has come. I would be aware at least. Your lordships may kindly see page 26. This order is absolutely bereft of any reasons, my lords.
That is a communication to the bank.
It is a communication to the bank. And your lordship may kindly look at the language. It is to inform that during the course of investigation, the below noted account number is found to be involved in the instant case. What is the involvement, my lords?
Anyway, you see, there must be something.
At this stage, my lords, I am praying your lordship may issue notice, the state will come.
Who is appearing for the state?
We've served office of the state.
Yes, Mr. Khan.
It must be served in the office. We are yet to collect it.
Then
That's one of the reasons we didn't.
you made bank also a party.
Bank is a party.
Agree with the bank.
No, state. State.
ठीक है ना बिल.
But then why application of 482? You cannot get any relief before the trial court.
My lords, I am not aware of any trial, my lords, as against me.
No, but then your account has been freezed.
But without an order of the court, my lords. It is an order passed by this. It is an order passed by
All
the.
right, but then is it not that you can seek relief elsewhere?
My lords, I'll try and satisfy your lordships on this. But little that I've seen, my lords.
Question is the court is right now not rejecting your application on that ground.
My lords.
But then the court is also, eager to know that whether remedy is available or not. Maybe
I'll
it
try
may
and
happen.
assist your lordships on the position of law insofar as this is.
Because CRPC otherwise does not contemplate any power to freeze accounts, isn't it? Is it?
No,
Under 102, like this is something like that. I think
102 is very
yes,
limited.
that was a
Very, very, very.
limited.
because I do not know about the recent laws, but then in 90s there was a decision by Justice Manish Khanna, which said that no, you cannot freeze a bank account. This is not a power. This power is not available under Section 102 CRPC. But then Supreme Court overturned the decision, 1999, GV Pattai. Okay, and then said no, the investigating authority has the power.
Has the authority. No, it has the authority, my lords. There is no dispute.
But then what about the remedy?
That exercise, there are certain parameters under which that authority can be exercised.
My friend may be correct. How to exercise power. That is with the subject matter. And whether those materials were available.
Okay, heard Mr. K. Paul Learned Senior Counsel, assisted by Mr. Chandra Learned for the petition. Issue notice, returnable in 3 weeks.
My lords.
Mr. K. Khan, Learned AG appears. K. Khan along with Mr. S. Sangyapto.
Respondent
number 1. Step. The petitioner shall take step for service notice upon the response number 2 within 2 days.
Through registered post, my lords. Registered post.
Whatever way you do it,
My lords.
the normal course. Please step for 3 weeks.
Next order we have.
I'll oblige.
Item number 3.
Yes.
Time. Okay.
Your Lordship, I'm for respondent number 3. Your Lordship, kindly grant us 2 weeks' time to file our
This is a
objection.
bail matter.
Cancellation of bail, Your Lordship.
But then can this bench take up? Bail is not before this bench.
Cancellation of bail or bail cannot be.
It should have been pointed out at the beginning. On the other day, he noticed one matter. So immediately we have to pass order for listing it before the appropriate bench. Because Supreme Court has recently said that until and unless matter is if it is taken up by the court,
Judicial indiscipline.
this is impropriety.
Impropriety. What was your impropriety?
The decision came probably last week or before that maybe.
10 days back, Lordship. Yes. It was in the
Something like that. If it is a bail matter, it has to go before the other bench.
Okay.
Hard. So and so.
Respondent 1.
Matter appears to be related to the grant of bail.
Cancellation of bail.
Cancellation.
Cancellation.
Anyway, same thing.
Same thing.
Grant and cancellation will be same thing. Matter appears to be in relation. Grant of bail in connection with special POXO case number. Special POXO in moderating case number.
Yes, Your Lordship. Moderating.
Grant of bail by the special judge POXO Shillong in moderating case number
108/8 2022.
under section 3A/4 of POXO Act 2020. Since the matter pertains, since the matter is not in the roster of this court, the same request will be listed before appropriate bench. That will do. Yes, Mr. Khan, we'll just say request will be listed before appropriate bench.
Yes.
That will do. Matter request will be listed.
Item number 4.
Nobody even for the state also. You are there, Mr. Sangupta? No.
I am not there, but then I will have to ascertain and I will inform the concerned council, my lord.
No. Miss Shyam appeared. S. Shyam.
Yes, Shyam, she was on legs, my lord.
Anyway, if there somebody should be there at least.
Sorry, my lord.
Anyway, none appears for the petitioner. Mr. S. Sangupta, learned additional J's.
PP.
Additional PP is present for the respondent. List this matter after 3 weeks.
3 weeks, my lord. I'll inform, my lord.
Item number 5.
Yes.
Yes, Your Lordship. Your Lordship, steps have been taken, Your Lordship, but notice has returned unserved, Your Lordship. Your Lordship, may kindly allow me to take steps again, Your Lordship.
You will take fresh steps.
Fresh steps here.
Office note dated 9/11/2023 indicates that notice upon the sole respondent has returned unserved. Stop. Learned counsel for the petitioner, please. That the petitioner may be allowed to take fresh steps of notice for service upon the respondent. Stop. Prayer allowed. Step may be taken within 2 days.
Yes.
List after 2 weeks.
Public Lordship.
List this matter after.
Hearing. Item number 7.
May please, Lordship.
Yes.
Lordship, this is that matter where I am before Lordship due to the failure of the government to make a reference. This is under the old Act, no?
When this acquisition took place?
Well, the notification initial will come to page 11 of my petition. This 2009, Mala.
Yes.
But you can have a list of the dates. So on 24/11/2009, notification under Section 4 of the Land Acquisition Act was published.
Yes.
And thereafter, my lord, on 30/11/2009, another notice was issued by the Deputy Commissioner under Section 4, read with Section 17. Now, the 17
Emergency.
are the emergency provisions. I have annexed that at Annexure 2. Then 13/10/2010 was the notice under Section 9.
Okay.
Then upon hearing the parties, my lord, and not only me, other parties also were interested and present before the collector, on 14/12/2010, an order was passed by the collector for hearing. My lord, this on 17/12/2010, notice was issued by the collector for payment of 80%, because, my lord, under Section 17, the government is required to pay 80% of the advance of the amount. That was also paid, my lord. Then thereafter, my lord, on 11/8/2011, I had written to the collector stating that I am willing to accept the 80% payment under protest. Even during that time, my lord, I had made a protest saying that the amount as fixed by the collector is inadequate. That also happened next, my lord, Annexure 6. Then on 30/8/2011, an amount of 14,16,656 was paid, which is 80% of the total amount of compensation, my lord. Then on 17/10/2012, the remaining amount was paid to me. And on 8/11, they say that on let's take the date as 7/12/2012, a petition was filed by me for reference in terms of the LA Act.
You said you received under protest.
Yeah, even in the initial stage, when 80% of the amount was paid to me,
Yes.
I had received it under protest. My lord, will come to page 20 of my petition, of the writ petition, my lord. Interestingly, my lord, at page 20, this undertaking was a form which seemed prepared by the collector in respect of all the petitioner and all the other landowners. My lord, will see. I'll just read. I, the undersigned landowner of land measuring so and so square meters, situated at village ward number so and so, Mendipathar, acquired for the construction of a new BG railway line from Durnoy to Mendipathar under East Garu Hills, do hereby accept the 80% of the total estimated cost of land compensation on so and so, which is payable to me as shown below, is fair, and I agree to accept the same without any protest. This was a typed copy, my lord, form.
No, but then you signed it.
I signed it, but my lord will see. Will see a signature of the landowner received under protest. I have specifically mentioned that no. I have every right to make a protest, my lord. So it would appear that the collector...
You have a right to make protest?
Yes.
You have a right not to make protest also.
Yes. But I have chosen to protest, my lord. Although the form as prepared by the collector would appear. So anyway, my lord, this was for the amount of 80%. So at that point of time also I had made a protest. Now, Your Lordship, what is important is the affidavit filed by the government.
What is the reason given by them for not referring it?
My lord, will kindly come to the affidavit in opposition filed on behalf of respondent number 2. This is the stand of the government. Now we'll come to page 7.
Yes, Tambe.
Yes, yes. Now we'll come to page 7. Page 7, paragraph 16, my lord.
Yes.
Now, with regards to the averments made in paragraph 15 of the writ petition, answering deponent humbly states that the petitioner's reference application was dated 27/11/2012 and was submitted to this office only on 7/12/2012 after more than 7 weeks, 50 days to be precise, from the date of the final award on 17/10/2012, and therefore could not be considered as the same was not filed within the stipulated period of 6 weeks. It is pertinent to mention that the date of filing of reference petition can be taken only from the date of official receipt, and not the date as mentioned in the reference petition. It may also be mentioned that the petitioner, despite submitting the reference petition only on 7/12/2012, that is after 7 weeks from the date of final award, mentions the date of his petition on 27/12/2012. So from their averments, it is very clear that they say that my petition is time-barred, and that the final award, was passed on 17/10/2012. This was the initial contention of the Deputy Commissioner. And this was made on the basis, my lord, of we'll come to page 11 on the basis of annexure 1 to their affidavit, the same affidavit, my lord.
Yes.
My lord, we'll see page 11, annexure 1. My name appears at serial number 3, my lord. Number 3. And before that, my lord, this is on the upper portion of the, this is a consolidated voucher for payment of 80% final payment of compensation for the acquisition land for construction of the new railways also. So this was actually a voucher. That's what in my rejoinder also I've stated. And it is not an award. See, Marcela Moomin was paid 11,40,340, and the amount paid was 9,12,272 on 30/8/2011. This was the first payment, my lord. And my lord will see towards the right, the second installment was made on 17/10/2012.
Yes.
So the contention of the collector is that the final award was the date on which I had received this amount, 17/10/2012.
Yes. That is the second payment, 20%.
Yes, that is yes, yes. So as per this is the first, because my lord, I'll come to the second additional affidavit. Initially, when they had filed the affidavit, the collector has taken the stand that the final award was on 17/10/2012.
Yes.
The date on which I had received the 20% amount. And my application for reference was made only on 17/10/2012, which is time barred in terms of section 18.
Your representation was filed on 17/12/2012.
Yes, as their contention is that.
Yes. What you are trying to point out from this annexure 1, the date of receipts.
Yes, that's what that's their stand.
So any contradiction between the averment made here and this?
Yes, because they have filed an additional affidavit subsequently. I will come to that.
But as of now, there is no contradiction between para 16 and this.
No. As of now, there is no.
It supports each other.
Yes.
Yes.
Well, my lord, before we go a step further, we will come to section 18 of the Act. To understand the issue, my lord.
Yes, 1 minute. Yes, one of you can go. One of you can go. One.
Well, my lord, in my rejoinder to the affidavit filed on behalf of the collector also, I have taken a stand saying that a consolidated voucher is not an award in terms of section 11 of the Act.
No, but then what is the date of award? What is the date of award? If it is not, okay.
No,
this is not an award. Definitely it is not an award.
Not an
It
award.
cannot be award.
So several chances were given to the government to produce the records before this court. And it was not done. But eventually, my lord will come to the additional affidavit filed by the Deputy Commissioner. An additional affidavit, this was 23rd May 2023.
Page 14. Page 14. 1411.
My lord has got the additional affidavit?
This one. Yes.
Now this is the additional affidavit filed in compliance to the order dated 21/4/2023 to bring on record certain documents from the original records placed before this honorable court during hearing of the matter. My lord, this additional affidavit now is filed by another officer, and he says that I am the Deputy Commissioner so-and-so. Then para 2, my lord, that actually the land compensation was paid to Srimati so-and-so, an amount of rupees 17,70,820 as land compensation, which is reflected in the award statement dated William Nagar 14th November 2011. The petitioner herein, Prakash Momin, is only the power of attorney holder of Srimati Marcella Momin. So now, with this additional affidavit, my lord,
yes,
their contention is that the award was is dated 14th November 2011. And they have a next copy of the award also, no? It is at page 6, annexure 8.
Yeah.
In fact, this amounts to misleading the court. Now you take a stand in your initial affidavit saying that the award was on such and such a date. And then, my lord, after 3 years, I think, after 4 years, they file another additional affidavit saying no, the award statement is 14th November 2011.
In their earlier affidavit, they did not mention the date of award.
No, they said 1712. My lord, will come back.
1712 is this.
They have specifically stated that the date of the final award is on 17/10/2012.
And what is the date? It is stated there in the affidavit. This one is.
And this one is 14/11.
Yes. And the other one, the first one was
17/12/2012. 17/10/2012.
Yes. Then. But then, which way it helps your case?
No. Now, my lord, we'll come to the law now. 18, section 18. Now, my lord, we'll come to section 18. Because the issue to be decided here is whether my petition is time barred or not. Let's come to that core question, Lord.
Yes. If we take into consideration both the dates, then it is time barred. 14/11/2011 definitely time barred.
Yes.
Even 17/10 also.
Otherwise also.
Beyond that
No,
6
no.
weeks.
The 17/10, then it won't be time barred, Lord. Let's go to section 18, Lord.
Yes.
Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for determination of the court, whether his objection be to the measurement of the land, the amount of compensation, the persons to whom it is payable, or the apportionment of compensation among the persons interested. Now, 2. The application shall state the grounds on which objection to the award is taken, provided that every such application shall be made if the person making it was present or represented before the collector at the time when he made his award, within 6 weeks from the date of the collector's award. B. In other cases, within 6 weeks of the receipt, now this is important, my lord. In other cases, within 6 weeks of the receipt of the notice from the collector under section 12, subsection 2, or within 6 months from the date of the collector's award, whichever period shall first.
So you covered by clause B because you were not present at the time of supervision.
Yes, not present. Now, my lord, I've brought your lordship's attention to the decision of the Supreme Court on section 18B. Well, it still has that.
Yes, one minute, just one minute.
My lord, the Supreme Court has said not only the notice. As per the requirement of section 18B,
Yes, 2018 ATCC.
2012-5 SCC, my lord. This is the leading case. I don't want to go into other. There are many decisions.
2012-5 SCC.
Yes.
250.
250. Yes.
Yes.
My lord will come from para 12, 255, page 255.
Yes.
An analysis of the above reproduced provision shows that by virtue of section 12(1), an award made by the collector is treated as final and conclusive evidence of the true area and value of the land and apportionment of the compensation among the persons interested. In terms of section 12(2), the collector is required to give notice of his award to the interested persons who are not present either personally or through their representatives at the time of making of the award. Section 18(1) provides for making of reference by the collector to the court for determination of the amount of compensation, etc., Section 18(2) lays down an application for reference shall be made within 6 weeks from the date of the collector's award, if at the time of the making of award, the person seeking reference was present or was represented before the collector. If the person is not present or is not represented before the collector, then the application for reference has to be made within 6 weeks of the receipt of notice under Section 12(2) or within 6 months from the date of the collector's award, whichever period shall first expire. The reason for providing 6 months from the date of the award for making an application seeking reference where the applicant did not receive a notice under Section 12(2) of the Act, while providing only 6 weeks from the date of receipt of notice under Section 12(2) of the Act for making an application for reference where the applicant has received a notice under Section 12(2) of the Act is obvious. When a notice under Section 12(2) of the Act is received, the landowner or person interested is made aware of all relevant particulars of the award which enables him to decide whether he should seek reference or not. On the other hand, if he only comes to know that an award has been made, he would require further time to make inquiries or secure copies so that he can ascertain the relevant particulars of the award. What needs to be emphasized is that along with the notice issued under Section 12(2) of the Act, the landowner who is not present or is not represented before the collector at the time of making of award should be supplied with a copy thereof so that he may effectively exercise his right under Section 18(1) to seek reference to the court. In so and so, this court was called upon to decide whether the expression date of award is to be interpreted with reference to the time when the award is signed by the collector or from the date the affected party comes to know about the same and held as under. Therefore, if the award made by the collector is in law no more than an offer made on behalf of the government to the owner of the property, then the making of the award, as properly understood, must involve the communication of the offer to the party concerned. That is, the normal requirement under the contract law and its applicability to the cases of award made under the Act cannot be reasonably excluded. Thus, consider the date of the award cannot be determined solely by reference to the time when the award is signed by the collector or delivered by him in his office. It must involve the consideration of the question as to when it was known to the party concerned, either actually or constructively. If that be the true position, then the literal and mechanical construction of the words, the date of the award, occurring in the relevant section would not be appropriate. There is yet another point which leads to the same conclusion. If the award is treated as an administrative decision taken by the collector in the matter of the valuation of the property sought to be acquired, it is clear that the said decision ultimately affects the right of the owner of the property. And in that sense, like all decisions which affects a person, it is essentially fair and just that the said decision should be communicated to the said party. The knowledge of the party affected by such a decision, either actual or conclusive, is an essential element which must be satisfied before the decision can be brought into force. Thus considered, the making of the award cannot consist merely in the physical act of writing the award or signing it or even filing it in the office of the collector. It must involve the communication of the said award to the party concerned, either actually or constructively. If the award is pronounced in the presence of the party whose rights were affected by it, can be said to be made when pronounced. If the date for the pronouncement of the award is communicated to the party and it is accordingly pronounced on the date previously announced, the award is said to be communicated to the said party even if the said party is not actually present on the date of pronouncement. Similarly, if without notice of the date of its pronouncement an award is pronounced and a party is not present, the award can be said to be made when it is communicated to the party later. The knowledge of the party affected by the award, either actual or constructive, being an essential requirement of fair play and natural justice, the expression the date of the award used in the proviso must mean the date when the award is either communicated to the party or is known by him either actually or constructively. In our opinion, therefore, it would be unreasonable to construe the words from the date of the collector's award used in the proviso to Section 18 in a literal or mechanical way. My Lord, by this decision, the Supreme Court has said the not only notice as contemplated under 18B is required to be sent to the party, it is also a copy of the award to enable the landowner to make a constructive, proper representation. Now, in this case, Malan, as you'll see from the affidavit filed by the collector, they're not even sure when was the date of the award. They did not know. An award was never published. It was not made known to me. It was only made known to me now, even to this court. It's only when they filed this additional affidavit. During the course of hearing, my Lord, in fact, the court had asked the government to produce the records to indicate whether the notice was ever issued to me. That was not done. Whether a copy of the award was ever given to me. That also was not done. What the government has done, they have just made an additional affidavit stating that the award was passed on so-and-so date.
But then once you receive money, some amount, especially the final amount, 100% amount.
We didn't know, my Lord, if that was the final amount.
But then 80%, 20%, that is your signature says.
18% also I have already then, my Lord, if that is the contention.
That is not their question, that the contention, I do not, this court doesn't know till now what is their contention.
Yes.
These are the queries which are coming from the court.
No, my Lord, that also a protest is already there. When 80% was paid to me, I have already said that I am not satisfied with this amount. And my Lord, further, the Supreme Court has said even an oral protest is enough. Even an oral protest is enough. When it comes to the knowledge of the collector that I am not satisfied, that is enough. Making payment 18%, 80%, 20%, that is not enough. If assuming that 1710, let's, for the sake of argument, let's assume for a moment that the contention of the collector is correct. 1710 is the 2012, on the date when I received the other 20%. Then also I have 6 months, not 5 weeks, in terms of 18B. Because the award has never been published in my presence. Not a notice has been sent to me.
No, but then how do you receive the full amount? How do you receive your amount as 100% without knowing the award?
We don't even know that this is the full amount. Because
but then 100% means full amount. This 100%
when a land is acquired under Section 17, that is the emergency provisions. So an amount is made by the government. That is also not even an award. That is not an award. When the government pays me 80% of the amount which the acquiring authority has deposited, that is also not an award, madam.
Then on what basis 80% is calculated? How do you come to 80% then?
Yeah, that is the government which answer the question.
No, as per law. As per law. Which way 80% will be construed at the stage?
Come to Section 17.
You have to enlighten this court about all those things. What is the difficulty in production of records?
I don't know, Malad. That's why, in fact, here
the issue could have been solved from there without going into all those things.
Without.
Mr. Khan, why this? What is the difficulty in producing the records?
In Lordship, we had produced the record, except for the award statement. The record was produced. It was very voluminous record. We produced it. Then finally,
no, but then we just did the part where a word is there and where this acknowledgement by those people are there.
Possibly.
And if in the event somebody had filed any application for reference, those parts, nothing else.
why this
Subsequently,
does not mean
because of the court's order, then we brought that statement of award 14/11/2012. That was the only thing that was. Otherwise, the whole record, bulky record was, and a very limited issues involved, Your Lordship. The query that has fallen from the court, whether difference can be made, whether 18.1 is applicable or 18.2 is applicable. I'll satisfy Your Lordship.
Because the records were called for, my lord, if I remember correctly. Because I said, let the records be called for.
Yes.
Let us see from the records whether notice was issued or not by the collector at the time when the award was published.
See, senior counsel is correct, Your Lordship. That the notice
I
part was
also
not
didn't
there.
want to mislead this court. I said, let the records come.
Yes.
Show the petitioner that a notice was sent to you along with a copy of the award. I will withdraw the case.
Absolutely correct. That's correct statement.
That was the only question, why the records were called for. But then, as per the records, there was no notice, no such notice was issued.
no notice.
No.
Then what is the difficulty in referring it then?
That is the only question, my lord. Because as per the Supreme Court ruling, it can be 10 years also, not 6 months. Unless the government satisfies this court that along with the notice, apart from the notice, a copy of the award is sent to the petitioner and he has knowledge of the same. It is the date on which he receives a copy of the award and the notice that will be counted as the date
Of award. Yes. Now what happens when there are several claimants, several beneficiaries?
Then also,
for each and every one different date of that award will be taken as different.
No, it cannot be different. It cannot be different, my lord. The date of the award has to be the same.
No, but then if it is furnished on different dates,
Yeah.
if it is shown that it is received on different dates by
Yes,
different
that's what
claimants,
exactly has happened here.
so that means then the date of award will vary.
Exactly. That was my argument initially also. I said, how can award be different? Because in Annexure 1, page 11, I have received on 1710, others have received on 24/2/2012, another one has received on 21/1/2/2012. Different.
Now that is so far as the 2B is concerned.
Yes.
No, but then it, 2B doesn't say about this thing, the date of award. It has nothing to do with
But
the
the
date of
Supreme
award.
Court has interpreted, it doesn't say, I mean, a plain reading of 18B doesn't say so.
No, but then interpretation of the apex court, which you have read just out also,
Yes.
this also doesn't say about the date of award. This also confines to the receipt of the notice.
No, but the Supreme Court has been very clear, saying that date of notice should be reckoned for the purpose of computing.
Now, say supposing
Yes.
now nothing is coming forward, and we go by the fact that the award is of 2011, then even also that 6 months time, that also stands expired in such a case.
That stands expired from the date I receive a copy of the notice as well as the award. That's what the Supreme Court has said.
What is the language of then B, 2B?
Of course, reading it, but my lord, we are well aware what
Other
Supreme Court.
cases within 6 weeks of receipt of notice from the collector under section 12, subsection 2, or within 6 months from the date of collector's award, whichever period shall first expire. So in any case, after 6 months, everything goes off from the date of award.
No, Supreme Court has interpreted it otherwise. Now, my lord, we are bound by Supreme Court decision. 141 is the law of the land. I agree with your lordship. A plain reading of 18.2 would certainly show that the.
So it means the issue of reference can be kept alive for years.
Yes.
If a person is not communicated, and he is communicated after 20 years of the actual date of award.
Not only the.
Can it be law like? Can there be interpretation of law like this?
That is the interpretation of the Supreme Court. What can we do?
We are not here to question it. We cannot question it. It is beyond our thing, jurisdiction.
Exactly.
We are trying to understand the correctness of the things. Even the reading of a decision, you see, like sometimes we think it one way and getting the proper meaning.
And this is happening, my lord, not only in this case, in several other cases also. They do not, in fact, your lordship has rightly pointed out, in case of various claimants, let's say 100 or 200, there can be cases of that nature also. And they don't publish in the website also. At least if it's published in the website, the court can presume that constructive.
That is for the, like for modern era you are saying. They think about time when those...
And here they mostly are rural people.
The facility of internet and all those things were not there. The Litigation Act is of... this is quite old act, isn't it? This is
the old act. And your Lordship will see such format also has been printed by the Deputy Commissioner. In fact, the Deputy Commissioner, the collector should tell the people that you are entitled to go for enhancement.
Yes, that is their duty.
No, it's their duty.
That is their duty.
Now,
we are not going by this.
That.
We are saying that, okay, you have received under objection. We will not go by that the typed stipulation there. Okay. When DC himself has written that received under protection signed by it, that will, in any case, will override that the stipulation made therein. So that issue probably would not exist.
Supreme Court maybe.
But then what remains to be decided is the date.
Yes, whether my application is within time.
Whether this court has the power to extend the date, say supposing if...
No, that I candidly say no. If the government can show that the notice and the award was given to me and I have come much later than the period prescribed.
But then once you put your signature on the last 100% payment, that will be construed. Otherwise, how do you yourself will satisfy that you have received 100%?
Then my lord is 6 months. The my lord will comes back to that.
From the date of receipt.
17/10/2012.
From the date of receipt.
Yes. Because I don't have a copy of the award in 6 months. As per 12B. They have said that I've filed it after 5 weeks.
No, 6 months from the date of collector's award, not on the date of receipt. 6 from the date of award,
yes.
Not from the collector's receipt.
But award, my lord, even before this court, they have come only in 2023 and said this is the date of the award. What prevented them at that time, when we filed the writ petition and said that our award was in 2011? Now, who do we believe? There are 2 affidavits. In fact, my lord, if a private party had filed such affidavits, it will amount to perjury.
No, even can be for government also. Why not government? Government doesn't say in the different.
Even the government, courts generally they take it because DCs they change. I mean, this is a very wrong information given.
No, but then these are the things, informations are based on records, not from personal knowledge. So it should not be variance.
There should not be variance. Once you have taken a stand that the award is on 17/10, how can you subsequently file an additional affidavit and say the award was in 2011? There has to be a reason.
17/10, do they say there is a award? This is, if you see, para 16.
No, this is a consolidated voucher.
Do they specifically say that that is 17/10 is this?
They say in the affidavit.
That paragraph 16 which you have referred.
Yes.
Just let us again see what is the language used here.
That's at page 7. That the petitioner's reference application dated 27/11/2012 was submitted to this office only on 7/12/2010 after more than 7 weeks, 50 days to be precise, from the date of final award on 17/10/2012, and therefore could not be considered as the same was not filed within the stipulated period of 6 weeks. I can understand the dilemma of the court also, and because we are also in a dilemma. Because on on the one hand you said 17/10/2012. On the other hand, you said in 2011.
See, that is probably the date on which he
received
the amount.
Yes.
That is perhaps there is something wrong with this slide. This should be from the date of this thing, final receipt of the amount, not from the date of payment. It has to be construed as a date of payment.
But can that be construed, my lord, in view of the additional affidavit filed by them and the copy of the award which they have annexed?
That goes back to then 14/11/2011. No, but then in such a case, you see, like your reference application is more delayed than if you go by that date, award.
Then I take recourse to the judgment of the Supreme Court. Either way, my lord. Because the award admittedly was not passed in my presence, and a copy of the same was never.
Then according to you, what should be the date of award for you?
The date of award has to be as per the records. That is
no, for you, so far as you are concerned, for computation of period of time.
It's from the date I receive a copy of the notice along with the award.
That is what the law says. But then you say you have not received any notice.
No. That's why I came to court also.
No, that is all right. But then what would be your stand at this stage? That so far as you are concerned, what should be the date
of the
award? So far as you are concerned.
In view of the conflicting stand taken by the government, my lord, who am I to say what is the date of the award? After they paid me this amount, I'm not even aware.
See, you are before this court.
Yes.
And you say that no, your application was within time.
Yes.
And it should have been referred.
Yes.
Now that has not been done. That is your cause of action.
Yes.
Now you come to court to project that your case is, your application was within time.
No, but when I came to court, my lord, I did not have a copy of the award. I only said, please refer the matter.
But then you had received your 100% payment.
My lord, we'll see page 20 again, annexure 7. If the stand of the government is that, I have already made my protest since on
that is at the time of receiving 80%, isn't it?
Yes. Because they say because if the contention of the government is correct.
Supposing if we go by the stand that at the time of making of 80% payment, there was no award in existence, then what is the question of lodging your protest at that point of time?
The question has flown from my lord, and that's why I'm coming to section 17. Because the amount has not changed. This amount of 17,70,820, this has not changed.
That is okay. That is okay. That is all right. Now, say supposing if your protest is to be considered as a protest under section 18,
yes,
then in such a case, there must be an award existing on that day.
There should be. There should be.
So, if any protest is made without any award in existence, can it be taken as a protest under section 18?
Yes, my lord, because it's their stand that the award amount is 17,7820 till date also.
That is all right. See why? You see, just because the amount is same, yes, we cannot say that you see, like the amount of 80% which was calculated at that time, it was out of any award. No. The amount maybe it might have tallied at a later stage, but then as on the day when you put forward your objection, There is no award in existence.
No.
So that can, it means that that objection cannot be regarded an objection under section 18.
Let's take that for yes.
Okay. Now only thing is that section 18 will come into play when award is in existence.
But award
Whether
comes,
award is in
comes
existence,
into existence, my lord, on my knowledge.
so far as you are concerned. Yes. But then you see, the moment you raise an objection with regard to the rate, that will give an assumption that award is in place. Otherwise, how you would know the rate? A person,
yes,
without, say supposing you say that I have not received, then if you have not received, then how you have filed your objection? That means your objection, the law says your objection has to be based on grounds. You have to raise specific grounds. And you can raise grounds only when you see a word. Can you maintain a stand that you have not received the award at the same time you have raised your objection?
Yes, my lord, why not?
Then what about the grounds then?
My lord, because the grounds are already there. We have stated.
No, I'm not talking about that. See, I do not know whether you are getting exactly the query of the court or not. A person can file objection only when he comes to know about the details of the rate, isn't it? Your objection will be definitely based on certain reasoning.
Yes.
That award given is not according to the market rate or something. You see, whatever it is. Now, for that, you need to see the award, isn't it?
Even if I don't see the award, my lord, if I calculate, this is the amount which has been given.
Which you have received.
And this is the amount my land. On that basis also I can make an objection. But it's too less. And what exactly I have done.
By looking at the amount?
Yes. If that is the query, my lord, if I calculate, I said, no, this is too less for such a big area of land. Because here, my lord, the entire controversy has been created by the government itself. They could have only given a copy of the award. There are around 17 claimants, and matter would have been closed.
Now, what would be your stand before this court?
Yes.
That so far as you are concerned, what should be the rate of award?
64. As I have stated, my lord,
you have to take a stand.
1710.
1710.
I have not taken any stand, my lord. My case is that there was no award. My case was that there was no award. Money was paid, no doubt, money was paid. But that cannot stop me from coming to court and say that more money should be paid to me.
No, you are getting benefit.
It's for the government to.
It is, you are getting benefit. Why should you come and say that no money should be paid to you? Okay. Now, the problem is that in absence of any definite stands on your part, which way you compute the period?
My lord, how can a landowner who has not been given any notice by the government take a stand that the award was passed on such and such a date? It's because of the delay of the government. That's why I've come to court.
It means, so far as you are concerned, till now, we cannot say a definite date of award.
Yes.
Now today,
because
say supposing now, right now, a copy of the award is communicated to you. So then today should be taken as the date. And you will have that time in terms of section 18.2.
It can be taken that way also. On the date they file, they give me a copy.
It's becoming unnecessary.
Yes, unnecessarily.
Because there already stands your objection. So making another objection,
it will not serve the purpose.
Now, how do we come to a conclusion that your objection was within time or not within time, as the case may be?
That's what we have to go back to 18B and the interpretation of the Supreme Court. That is the only way which can be resolved.
It becomes difficult for a court to form an opinion. At least, especially, even if you have to apply Section 18. For
We have to
completion of
apply.
period.
We have to apply, my lord, because the stand of the government is that my application is time bound. It is 5 weeks.
7 weeks.
7 weeks.
No, definitely they will be saying it on the basis of certain date, saying that is the date of award.
Saying that 1710, but
No.
then subsequently they come with another affidavit and saying it's in 11.
No, even if it is, let us take say 11, that also doesn't give you any relief.
Huh?
If they say that it is in 2011, that also basically doesn't add to your case, isn't it? So far as your stand is concerned.
Yes.
11 is
Even if it's 11, even if it's 12.
earlier than 12.
Yes. Even otherwise also, since they have not given me a copy of the notice and the award, it doesn't matter.
No, what would be your prayer before this court now?
My prayer, my lord, is simple prayers for reference.
But that is possible only if we can determine the dates.
That the
We can
government,
say-
government has to determine the date, not the court or not me. The government has to come with a definite stand.
What is the date of award?
Yes. Let them make the submission.
Let us see. Then, if required, we'll come back to you again. Yes, Mr. Khan. What would be your, according to you, the date of award?
Lordship, allow me to persuade to just clarify a very important legal issue has emerged. Whether it's 7/10/2012 or 14/11/2011, both situations is not helping the petitioner's case, because
That
in
is
both
all right.
situations-
But then what should be the date according to
Lordship,
you?
Lordship, let me just allow to clarify the position. If that is the situation, then what has fallen from your court is how would the court decide? Now, Your Lordship, if you come to my affidavit, page 18, Annex A5.
Which affidavit?
My first affidavit, state affidavit.
Which the learned senior counsel referred just now.
I'll just come to it, Your Lordship.
Yes, page
18, Annex A5. Lordship, the Supreme Court judgment again needs interpretation. So I'm just trying to persuade Lordship. Maybe I may not be correct. I'm just trying to.
No, you have to be correct. Otherwise, it will be difficult for the court.
Then assume, Lordship, I'm correct. I'm into the legal issue of constructive knowledge.
Yes, there is a representation.
Lordship, can you allow me to go slow?
Yes.
Because that will answer your query. From Prakash Mohammed, so and so. Lordship, can you allow me to start from below first? Can you see a Xerox copy?
One second. Just. Yes.
Lordship, can you see the notary seal is there? And then right side, Office of the Deputy Commissioner is Garo Hills.
7/12.
Receipt number is 8094-712-2012.
Yes.
Lordship, kindly note the date. And then, Lordship, allow me now. Address from Prakash Momin, petitioner to Honorable Deputy Commissioner. Dated is 27 November 2012. This is our stand also, Your Lordship. That the date of this letter was typed on 27/12.
Yes. That you have to state it specifically in paragraph 16.
Absolutely, Lordship.
Yes.
So, date of receipt is 7/12/2012. This particular. The next part is very important, Lordship, the subject. Lordship, I'm addressing how would you know the date? Constructively, applying the Supreme Court judgment, the principle of constructive knowledge.
Yes, please.
That is a legal position.
Yes.
Constructive knowledge. Prayer for referring to the Honorable Reference Court.
Yes.
In connection with acquisition of land, so and so.
Yes.
So the subject is for referring to court, so and so. Referring to what? So we have to go by implied constructive meaning.
No, that is definitely section 18. There is no question.
We are not denying it.
I don't think they will dispute it. Yes.
No, para 2 is important, Lordship. Para 2 of this application.
Yes, please.
That an award of rupees 17,70,820
has been made.
Now, has been made. They are not talking about the award made by the state under section 11 or 12. We are not into that. But
no, your submission would be that on 27/11.
I'm treading a very subtle ground. So I have to disengage two arguments that I'm forwarding on facts. Their submission in this reference is this. First is the texture of the application is referred to the reference code under section 18.
Yes.
The most important issue involved is, are they referring it, saying that they did not receive their notice? Still they are aware of the award and they want to refer it.
No, if once they are aware, that means that would be sufficient compliance of this.
No, I'm coming to that. Just allow me. I may be wrong again, but as Lordship says, I have to be correct, so I'll try to be correct.
It seems the court has a lesser patience than you. Anyway.
I should be thankful to Lenin Senior Counsel for bringing out a very interesting issue of law involved in fact, but it's a grey area a bit. So, Lordship, the second paragraph had the second paragraph said, we are referring this letter, Lordship. In spite of the fact we have not received notice, which is mandatorily required, we don't know what is the date of the award, but still, as abundant caution, we are referring it. Then the whole texture of this letter would have been different. So that argument goes. It is not the issue of not receiving notice. And things which I have stated here, they cannot improve in the writ petition. Lordship, Nazir Ahmed, Motiram and MS Gill, facts stated in affidavit cannot be improved. So, argument has to be confined to this particular. This is a very important letter. So, it is not the case that they have not received notice, and it is not the case that the limitation period will not start because of...
Once they said that they are aware of the award, then it's okay, everything is over.
Absolutely. But they are saying that they are referring this on the award. In clear terms, they are taking the starting point, which is 1712. So if that is the starting point, that means constructively, reference has been made on the basis of full final payment. And they are aware of the award, though they have not stated specifically. Now the issue would be for this court, once they mention this amount, 1710-2018-20, in our statement of award of 14/11/2011, Lordship, at serial number 60, Lordship, can you note down, at serial number 60, this amount is mentioned. 1770,820. There is no change of amount anyway. The amount so far petitioner is concerned, this amount is final. So they are constructively aware. There was a statement of award. In either case, whether 712, I agree with my learned senior counsel, Lordship, state has a bit created a problem for itself by not coming very clean with that.
That is one question, one pertinent question.
Lordship, yes.
We have to say something on the basis of the official record.
Absolutely.
Why there should be two different...
Absolutely. Lordship, maybe the tenor of the language.
We are seeking clarification of that. Irrespective of what we decide in this matter,
yes.
But then we'll be seeking...
Lordship has to, absolutely. Because the tenor of the language, we have to be very clear with that. But then, Lordship, if there's a conflict between a statement made on oath and a record, definitely public document, Lordship, the documents will prevail. A note of caution has to be given that in future it has to be very clear. But if the affidavit contradicts the record, official version, then there's a case of misleading. Here, Lordship, the record speaks otherwise. And in any case, that's not helping the case of petitioner. Had it helped the case, had the official record helped the case and we had suppressed it, then maybe the benefit has to be given to the petitioner. Rather, it damages further. So I'm not going into that. So, Lordship, coming back to the issue involved here, constructively they are aware of it, though not in many specific terms, they have quoted section 11 or 12. What requires is that final line of distinction that the Honorable Supreme Court has observed. Constructively, we are aware of it or not. Now, this reference letter has all the tapping of invoking the power under section 18, number one. Second, it has all the tapping that the petitioner was aware of the amount. And the amount, we are on record. And that amount we find on echo in both the dates that we have mentioned. If that is the case, Your Lordship, whether you take 7/12/2012 as a date, which is a stand in para 16, or we take 14/11, in both the case, it is beyond 7 weeks. So the issue of notice, Your Lordship, The issue of notice per se will not arise, because if you see the entire letter, Your Lordship will come, this is a entire reference letter.
The payment was received on 17th October, isn't it? 1712.
And that is another view of the matter, Lordship. So for section 80 was concerned, 80% there was a protest. For the balance, when the balance was received, there was no protest. So there is slightly a distinction on facts, and which has been admitted also, fairly admitted by the senior counsel. So, Lordship, constructive notice. You can find the tapping of constructive notice from this letter itself. And representation very clearly, Your Lordship. And see even in the last paragraph, Your Lordship, if you come to page 22, crucial. In the above obtaining situation, it is humbly prayed that this petition be forwarded to Honorable Reference Court for adjudication.
No, that is detailed, very detailed, this thing, representation, isn't it?
It's on merit, but Lordship, the crux issue is this, the issue of notice. We are not into the merit part, Lordship. That would be taken care by the reference court, but whether we are into the way we are right now in the veranda of the reference court, whether the door should be opened. There have been none suited because of barbell law. So on constructive notice, Lordship, kindly go through minutely.
No, this seems that this representation has been filed after availing the assistance of experts. This has been signed by a lawyer also.
And the Lordship, then the Lordship,
there is no specific contention that you have not received the copy of the
Lordship, yes, that is what I was just trying to clarify. I said, I have to clarify that on this point. You have to go through minutely. Lordship, the whole answers that are fallen from the court can be answered by this.
Yes.
And the principle of constructive notice or being aware of it, it's implied in the facts and averment given in this letter itself. If that is the admitted position of the writ petitioner, Lordship, where would be the requirement of any further notice?
If I may, see, your petition says that, you see, like, if you read the entire text, it gives an impression that you are very much aware of the award.
Of course. I don't deny
all those.
My Lord, we'll come back to page 18.
Yes.
That's why the records were called for. Page 18, my Lord.
Yes.
Your Lordship will see the seal of the Deputy Commissioner. This is 8/11/22. Here also 8/11/12 on the left hand side. So that's why the records were called for. I had drawn the.
You are referring to page
18 of their affidavit.
The which Mr. Khan was referring to.
Yes.
And
Your Lordship will see on the upper portion, the left hand side. This is a seal of the Deputy Commissioner 8/11.
Is it not very visible here?
8/11/12. That's why the records were called for.
Is it 8/11?
Yes.
12.
Then down it's 7 to.
Even the seal below the Ashok pillar, there is a date. It seems there is a date appears.
Yes, my Lord. That's why the records were called for to a certain.
Mr. Khan, why don't you produce these records?
Yes.
We just produce these records. Let us see.
Let us see, my Lord.
Enough confusion. I do not know why it is.
But Lordship, if Lordship come to again, Lordship is correct. Lordship, we just come to writ petition annexure 8, page 21. Writ petition.
I see, like, instead of solving the things, your arguments basically is making more complicated for the court.
Lordship is correct.
From the very beginning, I said the government can show that notice was issued to me, and I was very much given a copy of the award. I will withdraw the writ petition.
Lordship, we just come
to happen like that. They have furnished you, but then they have not kept any acknowledgement.
But Lordship, we just come to
that because your application seeking reference, which has been filed, it is very thorough. It is not.
In fact, this was was annexed by the Deputy Commissioner. The one which we have annexed in our writ petition, which my learned friend wanted to show.
Page
21.
21. Lordship will just have a look.
There is another application.
There's the same application in Lordship, but this
is basically the same application.
Basically means it has to be exactly same.
It has
to be
exact same.
replica of another. It cannot be.
Lordship, it is exactly replica of same.
Replica, but there's no receipt or.
But Lordship will just come to page 25, the last part. How it was been said, nothing has been mentioned. So, Lordship, page 25, last part. You don't know whose signature is this? 28/9/2011.
And this lawyer signature is also not there.
Lordship, you can't see this.
That's why I said
something is wrong.
Lordship, this is a writ petition application.
You cannot say this is the copy of the same.
Yes, but this copy has been annexed in the writ petition.
So do you want to say it is a manufactured document?
Lordship, I'll not go so far. I'll try to restrain myself.
It has to be.
I'll have to restrain myself. Lordship, I'll leave it to the inference by the court.
Yes, Mr. Diengdo, it appears to be something wrong here.
Exactly, Miller. That's why I said from the very inception of the hearing of this case, I said let the records be called for.
See, the record.
The records will speak for themselves.
Do you want to say that record will have the copies of both these?
Perhaps, Miller. That's why I said for the records also, because the award.
In this application,
yes,
there is no acknowledgement by the.
Nobody, yes.
And then you have appended it with your writ petition.
Yes.
Yeah, that is the important.
We append what our clients give it to us.
So you cannot say that it is the wrong one.
Yes.
For you, this has to be the right one, not the other one.
Absolutely correct.
For you, so far as you are concerned. It will be any difficulty in production. At least you can produce those.
Lordship will produce it. Will definitely produce it. That is.
Let us verify, since once we are into those things.
We are into the constructive notice part.
You say it is voluminous. Why it is voluminous?
Lordship, voluminous in terms of, because Lordship will say, there are 64 beneficiaries, 64 documents, the entire record was bulky and office.
We would not like to see those parts, those papers and all.
This was called in connection to
another matter.
And
so many interconnected matters, Lordship. The land acquisition proceedings, so sometimes
you see, like you can sort it out. We'll give you sometime, at least 2 weeks time. You can sort it out, the parts which are important for this case.
At least this letter part, Lordship. At least, in fact, this letter is very important.
This letter parts and that award part, and if the issuance of notice, you will be having at least a register and all.
Lordship, admitted fact, we have gone through the record. Notice was not issued. That's an admitted fact. We will not burden the court with unnecessary clarification, contact.
What is the difference of a proceeding under section 17 and the proceedings initiated by following those section 4, 6 and all?
Lordship, under section 17, it's an emergency clause to tide over emergency. 17(3)(a). Lordship will have a look at the section. The moment government takes possession, it has to give 80%. It stems from section 17(3)(a).
I think the question from the court is, how do you come to that amount?
That is exactly. Yes, so far as the preparation of a award is concerned.
Absolutely.
Yes.
So the moment 17 is then there are comparative analysis, market value, all the details.
Whether the right of the claimant is same in a acquisition under section 17 and acquisition under normal process of law.
Procedure wise,
so far as his right of being heard or the opportunities, which I think it remains the same, isn't it?
Lordship, it remains the same. That's why I'm coming. That's why I'm relying, Lordship, I'm relying very heavily on the representation. Can they improve the case from there?
No, that is why you are confining to this. We are asking a question of law, you see.
The question of Lordship, the rights will always remain.
Whether, you see, invocation of section 17, curtails of right of claimant.
It does not curtail, your Lordship. Only 80% is paid. Government bases the claim, but all the rights to agitate, claim, protest, enhancement, it all flows. Except, Lordship, this was the case with the Union of India. This was meant for the railway project. The land had to be acquired. And all other proceeding goes on. There is no bar into it. And they have the rights to come and challenge. Here, Lordship, the only fundamental question is this: whether the Honorable Supreme Court judgment is applicable in this case when there is a constructive knowledge of the notice by implication in the above. And whether, if that is a notice, only simple issue, Lordship. If that is a notice, apparently it is barred by law, 7 weeks. If that is not the notice, then there is a
in your writ petition, do you say when you filed that application?
Yes.
The date is the same. Or are you going by that date on 27/11?
We have to.
Now, even for the petitioner also, you also should not make any wrong statement in this petition.
Exactly, my lord.
Lordship, page 8, para 15. They have not mentioned. They have not mentioned the date. Para 15.
Para 15.
Page 8.
No date.
No date.
They should have been mentioned then.
And your Lordship, para 16, which Lordship had read from
Shows that you are also not very sure when it was submitted or at all submitted or not.
And Lordship, we have replied specifically.
Your petition otherwise shows the date 27th November. But then you have omitted to mention it.
Yes, my lord. You have not.
And we have replied, your Lordship.
They have replied that it was received on such and such.
Yes. No, that is all right. But then their petition, which they have, the copy of the representation, which they have appended, it seems different from yours.
Very different. And your Lordship, can you appreciate state is an impersonal machinery? What would be the need for state to change the date and do anything like that?
There is no question of changing the date.
So there is no.
Okay, because you cannot manufacture the signatures.
Absolutely, and there is no need. An official record comes, we register it. Except there is an allegation that everything has been done otherwise. And we have taken specifically, your Lordship, para 16, which Lordship had read out in our affidavit.
Because, see, paragraph 15 annexes is copy of the petition filed by the petitioner before the Deputy Commissioner.
Yes.
So, if you find that it is not the copy, then we will say you have not filed anything. We can say that. So, your assertion has to be supported by the record.
That's why let the records be called for.
Wrong from this side, wrong from that side. You see, like that is what something not very appreciable.
So far state is concerned, Lordship will verify the record, but there's no reason for state to put all those seals and just to, nobody would go so far.
The date of award, you see, that is what
that is correct.
You have to clarify that statement. Though court is prima facie of the view that it is wrongly awarded in that thing.
Yes.
Because,
yes.
By doing that.
But then, Lordship, the matter is very simple. We have to just address the issue of constructive notice.
My lord, this affidavit was filed in. This was filed in 2000 and. 2019, my lord. The first affidavit filed by the government was in 2019. And yet in this affidavit, nowhere have they stated an award was published or rather it was finalized in 2011.
Except for that statement in 2016.
Yes.
Sorry, paragraph 16, which you referred to in.
Yes.
And by which you say that the date of award is 17/10/2012.
So after 4 years, then they come with an additional affidavit which changes the entire nature of the case.
Well, that is where I do not know. You say it, but then that's 17/10/2012 statement at paragraph 16. That is something worded, you say, like wrongly. It doesn't specifically say that.
Even in my rejoinder, I have stated that 17/10/2012 cannot be an award. It is only a voucher. An award, as per section 11, there is a procedure.
That is why that is not meant to be an award.
Yes, it was not an award.
So award basically remains on 14/11/2012.
14/11/2012.
Whatever you say.
Yes.
That
Absolutely.
Yes. We cannot change that.
And if it is 14/11/2011,
nothing remains in the case.
Then I'll fall back on the Supreme Court decision because they say that admittedly notice was never issued.
Yes, that's what I was saying. And you're also going by their application, except for the date.
Notice was never issued because they already were present. They have the notice. So once a person appears, then why notice is required?
No, my lord, if you see our objection, it's always based on the objections which I had filed earlier, on our protests filed earlier. And my lord, we'll see from the affidavit filed by the government also, how we came to know about all this fixation. My lord, will come to page 13 of their affidavit.
Their which affidavit?
The government, first affidavit.
Yes, page?
Page 13. There was a full-fledged hearing, my lord, on 14/12/2010. The day is fixed for personal appearance of parties under Section 9 of the LA Act, issued earlier so-and-so, dated so-and-so. Interested parties have appeared today in person, and some through agents, to state the nature of their respective interests of land and particulars of their claims, if any. Peruse the record placed before me, and appears that there are a total of 65 numbers of interested persons involved in the land acquisition for new BG railway station, so-and-so. Each parties have been heard separately, one after another. Parties have been shown measurement of land and quantum of amount payable to them as compensation under Section 8 of the LA Act. As many as 48 of the interested parties agreed to the measurement made and compensation payable to them under Section 8 LA Act. So in this particular hearing, my lord, everyone was heard, everyone was shown how much we are going to get, what was the amount fixed for the trees and all that.
He says that there are 65 numbers of interested parties.
Some have accepted.
And then it seems like there are 66, one more here.
Yes.
48 person have not objected, 18 has objected.
Yes.
So it comes to 66. So where from that extra person comes?
So these persons, how 18 number? Yes.
Why there is a difference of one claimant, one person, interested person?
That I cannot say, my lord, because this is the document from the government.
This is from getting from your reading only. You said that there are total 65 numbers of interested parties.
No, this is affidavit filed by the government.
Yes, that is a government document, you see. No, but then see, it has come to notice just now, and then you have read out that as many as 48 numbers interested parties agreed.
Agreed.
And down below them say however 18 number of interested parties raised their objection. So 48 plus 18 becomes 66.
So one more.
One more.
So my lord, next page we'll see. So these are the names of the 18 persons. Next page we'll see. Your lordship will see the statement of each of them has been recorded as per provisions of Section 9 of the LA Act. After having heard all the objections raised by each of the interested parties, I am of the view that the veracity of the claim and objection has to be verified thoroughly on the spot. DSDO Civil Resu Belpara, along with the officials of GHADC, shall cause a spot inquiry and submit report within 14/1/2011. Fix 14/1/2011 for report. After this, there was no more communication. My friend has said that from my presentation, it shows that I know everything.
No, that is an assumption. That is an assumption. He did not say that officially it is resolved.
But because of this
His
hearing,
contention is that once you have the knowledge, the question of issuing notice does not arise. Notice is for the purpose of making you know, letting you know. So once you have the knowledge, what is the question of notice? It is something like the proceeding before a court. You appear, we do not issue notice.
no, what my learned friend is saying, that is a very detailed. How do I know? Because I know, because I have seen. This is the record from the government. They have annexed this. So on that date, when the hearing was fixed, we were shown. We were shown. Anyone, let them produce the records and see.
We do not know where we will end up. This is something, seems like, if we basically dwell on those contradictions and all those things.
Lordship, yes, that is what I was coming
to.
If your Lordship, the initial burden is for the petitioner to discharge, that notice was sent to the Deputy Commissioner, because we only the last line 2811. Not receive nothing. For them to discharge it, there was a letter sent.
You have one way you have raised with regard to that representation. No. But then at the same time you do not deny that you have received. You have received. Your official record says something.
Received, Lordship, when we say receive, the date is crucial. We are only into the date part.
No, but then that is not disputed, that part. So far is the...
So Lordship, if date is not disputed, then it's beyond 7 weeks.
That is means like that is you received beyond 7/12.
Beyond 7, then it will be beyond 7 weeks.
No, that is by this Lord Senior's interpretation.
The moment we accept that date.
He said that award has not been furnished to him.
Lordship, that is what Lordship is what was fallen just now. If the date is fixed and the lawyer appears, whether notice is required. If you apply the same analogy, Lordship, if you apply the same analogy, you have moved before a reference court without knowledge of the award.
In the same judgment, my lord, in the same judgment which I referred to, we will just have a look at paragraph 22, the last. Now, we're talking about burden of proof, huh?
Paragraph 20?
22. Yeah, my lord, on behalf of the state government, no evidence was produced before the reference court to show that the copy of the award was sent to the appellant along with the notice. Unfortunately, while deciding issue number 3, this aspect has been totally ignored by the reference court, which mechanically concluded that the application filed on 8/4/1985 was beyond the time specified under section 18(2)(b). The learned single judge of the High Court also committed serious error by approving the view taken by the reference court, albeit without considering the fact that the notice issued by the collector under section 12(2) was not accompanied by a copy of the award, which was essential for the effective exercise of right vested in the appellant to seek reference under section 18(1)(a). So this is a case, my lord, where the notice was in fact sent, but the copy of the award was not sent. Even then the Supreme Court said it is not enough.
Lordship,
Now,
can
is this
can
a
I-
case
can I-
where-
Can I insist the court, Lordship, in this observation part? Here is a case where the reference court is appreciating whether notice on the award was given or not. Our case stands materially on a different structure. Our case is, Lordship, whether the Deputy Commissioner should send it to a reference or not. We are still in the transit. That aspect, I'm not sure Supreme Court has
This
decided.
is also not a case where the claimants are prevented from filing an objection.
Yes.
The claimants have filed an objection.
Yes.
Now, in this case, before the apex court,
Before
was
the
it-
apex court, the question, the reference was rejected. The reference
Court
was
rejected.
on the ground that it is barred.
Yes. Here, Lordship,
the referee court rejected. Isn't
Yes.
it?
And our case is the Deputy Commissioner is yet to take a call, and
But it's the same principle. Here the collector has said it is time barred. This is the case. Before the Supreme Court, it was the case of the reference court had.
Lordship, senior counsel is correct in so far that aspect is concerned. But on factual aspect, Lordship, we are in a different footing. Now, this court has to decide whether it is hit by limitation or not. We are neither before reference court nor before Deputy Commissioner. They are before this court on the inaction of the Deputy Commissioner to act. So whether this court will agitate, whether these material facts are present for this court to pass an order directing the Deputy Commissioner.
No, we are not going into all those things. I don't
Nee,
think
that is the
why
issue
to
that-
make things more complicated.
Lordship, but that is the issue, that part has not been covered by Supreme Court judgment. But on the other aspect of law, yes, Lordship is correct. Senior counsel is correct. I thought I'll just assist the court by bringing that fact. Court can overrule my submission. So we have to still overcome whether our stand is 7 weeks delay. And when a senior counsel submission is there, whether notice is mandatory or not. So the court has to decide whether constructive principle of notice will be
Your
applicable.
stand is 7 weeks delay.
And
It is
notice was away.
irrespective of the fact of whether the date of award is 14/11,
Yes.
2011 or 17/10. In
Because
both the cases
constructive-
also,
when
both the
constructive-
cases, so
yes.
definitely for you it's open and short case.
Lordship is. Because they have set into motion the application by filing
The
before reference.
problem with the contention of the petitioner is that, you see, the thing is that what is the date of award for them?
Absolutely. That is what I answered, Your Lordship, constructive.
Now we have to decide it by taking into consideration the representation which has been.
Yes, that is the crux.
There is no other option.
There is only a crux. That's why I started my argument by coming to that representation. I started my argument on that.
It's a given situation, there is no other option, at least for the time being.
For the
this
time.
court, I don't think that is.
I started off with that, Your Lordship.
It seems there is no other way out so far as this thing is concerned.
But then,
The
my lord, even-
decision basically is with regard to the notice.
Yes.
But then once there
But
appears.
then, my lord, 7 weeks will not be applicable, then 6 months will come into play. Because they haven't been able to show that the award was passed in my presence. That also will come. They say it's time barred because it's filed after 7 weeks. And my lord will see 18(1)(b) says for 6 weeks or 6 months. 6 weeks is if the award was passed in my presence, and 6 months if it was not. So then also I'll come under the.
So that means, like, if it is, say, supposing, if it is taken If it is 17/10/2012, if the period is to be counted, then it is within 6 months.
Yes.
That would be your, that is what your case is. So your case, we can say, like, if you can make it simpler, I do not know.
Yes.
That award was never furnished to you. So far as you are concerned, no date of award can be ascertained. Now, in such a case, we will go by the date on which you received the thing.
Received the amount.
And then 6 months will come to play.
6 months will come to play. That is my simple case. Simply put it.
This code has simple understanding. That is what the problem is.
No, we should complicate the matters too much. So we are here to.
Yes, we have to assist the court. Absolutely. We are ourselves traversing into disputed issue of facts.
When can you produce the record?
Record is here. It was called.
No, I think
the letter part.
I think what the court wants is you.
The letter part, Your Lordship.
We'll check the letter part.
My friend has been handling this since 2019, so I will rely heavily on him.
Records were called in connection to another case, another LA case. So
Record for determining that representation.
Yes.
So which representation is there? With the copy of which they have appended in their thing, or you copy which you have?
No, let's come up next week.
Next week, let's go through, Your Lordship. Yes.
Let them go through the records.
And that part, if you can ascertain, the notice part.
That is the only issue, Lord. Constructive notice.
Can it be in case of Land Acquisition Act?
The Supreme Court judgment says that.
I mean, the Supreme Court also sometimes they complicate the issues more. Instead of you read one judgment, that's why I'm going to have confined to one judgment. There are other judgments also.
This will be improper for this court to agree with your proposal.
Lalit Counsel, Senior Counsel was going very well on the law part, Lordship, except for the facts. I'm sure he was not handling.
You have the liberty to do so many things.
I wish he was handling this case the way he's argued the case, Lordship. I wish he was handling right from 2019. Things would have been very different. But unfortunately, we have to build up from where we get the brief.
Okay, hard. Just things at some length. After hearing the matter, it's some length. It transpired that production of the record pertaining to the land acquisition proceeding in the matter requires to be placed before the court. Stop. Mr. K. Khan, Learned AIG. Agrees to produce the record. After? 2 weeks, 1 week, or
2 weeks. Make it 2 weeks.
Please, if you have a time, please go through it thoroughly so that we can get it ready.
2 weeks.
There is always presumption of genuineness of the
record. Absolutely, Lordship, yes. Absolutely.
So whatever you get helping you, please keep it so that
anything,
go by that.
Anything.
So and so he agrees to produce the record after 2 weeks.
Please start. Oblige, Lordship.
Item number 10.
You have any role here?
You have to pay the money.
If you pay some extra money, you can finish it. You will say that you have agreed and we can.
Railways are very rich.
You can have a negotiation with him how much they want and all.
They are expanding well.
Much.
One second.
Jen.
Lordship, I beg to seek your indulgence, Lordship. Lordship, for item 13. This is a part-heard matter, Lordship, whereby the state was directed to produce the record of the investigation of the FIR in question. Now, I spoke to the respondent. They said they are yet to produce they're not ready with the report, Lordship. Lordship. I'm not sure, Lordship, but it was heard at some length. It's regarding questioning of the FIR, which is pending in Nongpo. During the course of the hearing, your Lordship had directed the respondent to produce what is the stage of the investigation of the FIR in question. I've spoken to the respondent. It seems it's not ready, Lordship.
What's the last order?
Produce the case diary, Lordship.
Lordship, we have not received the diary as yet. We'll seek for some more time.
It'll come after 2 weeks, Lordship.
Obliged.
May I please, Your Lordship? Your Lordship, I'd like to mention item number 12. 12, Your Lordship. What petition?
If that be the case, then after 3 weeks, Your Lordship.
2 weeks, Your Lordship. 2 weeks.
This is question of a POCSO proceeding, Your Lordship. Three weeks, Your Lordship. Yes. Apply.
Please, Your Lordship. Your Lordship, item number 11, Your Lordship, the counsel for the petitioner is nowhere. He's not available today. As per the cost list, he's on sanction leave, Your Lordship. And for the state, Your Lordship, on behalf of Miss N.G. Shala. No one is there, Your Lordship. And he's on sanction leave as per the cost list also, Your Lordship, Mr. P.K. Bora. Two weeks, Your Lordship. Obliged, Lordship.
Please, Your Lordship.